Tillman Breckenridge for the Commonwealth. I'd like to begin in the intervening election issue and then happy to answer any questions on any of the three issues. The reason for starting with the intervening election issue is that I'd like to break down the arguments on how each judicial philosophy applies, given the fact that there's been some discussion in the briefing about purposivism versus textualism and things like that. I'll start though with textualism and then work my way to purposivism. As a textual matter, the Constitution is pretty clear, as Mr. Seligman broke down. It states that the next intervening general election will be of the House of Delegates, and the House of Delegates is elected on the first Tuesday after the second Monday in November. Always hard to get that one straight. But given that, you also have other provisions in the Constitution that establish that by general election it means the first Tuesday after the second Monday in November. So, for instance, the one-year residency requirement establishes the nature of the election and the fact that one is elected on that day, election day. And so now, under the new regime that the respondents suggest, I wonder if we would then be stuck with a 1 year and 45-day residency requirement.
I'll ask you the same question. Why isn't it a natural reading to read the phrase election, the noun, as the process, and the verb phrase shall be elected as indicating the end of that process, or at least the voters' participation, the group that is the passive verb is referring to do something, shall be elected, is the end of that process. Because even on election day, you're not elected, and because you're not elected until you're certified, right?
That is correct, Your Honor, and that's why I want to use the Constitution's text primarily, because the Constitution treats both the word elected and election as that first Tuesday after the second Monday in November. But to the extent that we're talking about natural reading or dictionary definitions, if you go to the 1971 Oxford Dictionary, it defines an election as the formal choosing of a person for office, dignity, or position of any kind, usually by the voices of a constituent body. Now, I realize that could have gotten a little bit confused because the respondent's briefing appears to, as best I can tell, mush together a few definitions or maybe a couple definitions of election. I couldn't get a hold of a 1978 Oxford Dictionary.
But just to be clear, much like the Legislative Leaders Council, you agree that for you to be correct, people casting votes are not actively participating in the election when they cast their votes.
No, I disagree with that, Your Honor.
Okay, how am I, if I voted on October 21st, actively participating in the election when I cast my vote if the election hasn't begun yet?
Because you cast your ballot early, but your vote isn't counted until Election Day.
Well, that's the difference between casting and counting. I understand that your position is they're counted on Election Day. My question is, am I actively participating in the election when I vote? That seems to be the sine qua non of an election. I go and vote.
Well, I disagree, Your Honor, because you're casting your ballot before Election Day. Your vote your vote actually happens on Election Day when your ballot is counted. That is a vote.
So your interpretation of the provision is that we literally could have an election where every single vote is cast before the election actually even begins.
I guess in the abstract, perhaps, if everyone voted early.
That seems a very extreme definition of election to me.
It's the definition of the election that the Constitution gives, Your Honor. And if we are going to take a sort of living constitutionalist approach to it, where the definition of election kind of changes because we have new early voting procedures, then that would be sort of more of a fairness argument. And if we go to that direction, then I would say that I think it's inherently fair for anyone who casts their vote early, as I have in the past many times, to say that they should have to say to themselves, I am accepting that there's something might happen in the interim that is significant that might change my vote if I had waited. And so that includes an October surprise or the death of a candidate. And so the respondents have, kind of said, a mere October surprise. So they seem to be suggesting that there's an importance difference and a tough challenge to figure out what the standard would be for that. but I would have trouble figuring out something that's more important than the death of the candidate you voted for.
What is your position, your client's position, regarding a constitutional amendment that is adopted at 6 p.m. on election day, with an hour left at the polls? Is that the next Is that still the next general election? Because hey, you could have waited until 6:59 to go to the polls to vote. Therefore, that's the next general election because there's still 60 minutes left.
No, Your Honor, because the Commonwealth's position is to base the decision in the text of the Constitution, which establishes that election day is the election. So anything that gets passed must be passed before election day.
We've talked text. What about purpose? So one argument is we need this delay so that there's time for voters to educate themselves for debate, number one. And then number two, so there's accountability. So if the legislature swept on a tide of passion does something that the voters decide is bad, there's the opportunity then to hold them accountable in the next election. So we have text. You've addressed that very well. Help us with the purpose aspect of it.
Sure, Your Honor. The two answers to that, and both are based. Well, going with the purpose reason. One is based in establishing what the purpose really was, and then another based on even if the purpose was as stated, it would not be served by by affirming the court below. So to go to page 498 of the debates, where Delegate French Slaughter expressed the purpose of that provision, there were a few words left out in the respondent's brief, so I want to give the whole quote. He said, "Not only would there be an intervening House of Delegates election where you might be able to get the sentiment of the people on an amendment you had acted on previously, but upon reflection, the General Assembly might decide not to submit the amendment." So that you might get what the people think, and upon reflection, the General Assembly might decide not to submit the amendment. Suggests that there should be some intervening time, and that's the issue, is to provide an intervening time period for the General Assembly to change over to a new General Assembly, maybe hear from constituents, maybe not. But then 2 pages earlier, there's the discussion of the publication requirement and whether there should be a publication requirement. And Mr. Slaughter states in no uncertain terms that the whole reason for removing the publication requirement from before the next general election issue is that the idea is that the people get educated before they vote to ratify it. And so therefore, that is when people need to be educated, is when they actually vote. And so if we're talking purposivism here, if we're talking about the purpose of protecting the people's vote and protecting the people's ability to weigh in, then I feel like it would be patently unfair to override the people's vote because of a concern that they had not gotten to the opportunity to voice their opinion months earlier.
Regarding the special session surviving the convening of a general session, do you have any authority other than constitutional silence?
No, Your Honor, there's no authority one way or the other on it. It really just comes down to the fact that, and there is one thing I do want to correct on the record about that, though. There's a lot of discussion of 611 or 612 days of continuous session. But to be clear, the legislature did business a grand total of 14 days. They were not.
But contends they were in session the entire time. They didn't have to pass a new resolution by a supermajority or have the governor call them back in at their option. And weren't they actually pro forma continuing the session the entire time?
Yeah, they recessed the session several times. But the bottom line is, Your Honor, they were actually in session for 14 days. So
the session lasted the entire 2 years. Whether they did business during the session is a different question.
Well, perhaps, Your Honor, but the bottom line is there's no reason to start talking about how this legislature created some non-citizen or professional legislature. They were in for 14 days. They didn't violate any concept of a citizen legislature by remaining in recessed session for a long period of time. They only actually did business for 14 days. And so given that, and given the fact that there is no authority one way or the other, but the bottom line is that they weren't converting themselves to a citizen legislature, I really don't think that there's any constitutional argument that they somehow violated their powers as a legislature.